I'm jumping the gun. My learned friend must address you first. All I want to do to begin with is to place in context how we are sitting here before you today, which is we have filed our answering affidavit and heads of argument. We've received nothing from my learned friend, and we've not received a condemnation application or a postponement application.
All right, all right.
And I think once my learned friend addresses you on the merits, I can then turn to the merits.
Thank you. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, you will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the Commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the Commission by Ms. Adila Hasim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched to complete the forms for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMEX, follow the whole process, somebody to pick us up as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit, and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access, rather, to a computer where we could possibly send him an email, and maybe in the evening he could quickly just see what it is that we've said, and maybe then, before we arrive, he would have a position and we could proceed. On Sunday, Ms. van der Heever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand, and then hopefully we can get some instructions. Over and above that, while we're at the prison, we then receive another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glance through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they'd given us, quickly give him what we gave him, have him glance through the affidavit, at which myself personally I had not read through, and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the Section 204 affidavit so that he can adequately provide evidence depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. van der Heever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a lay person not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala, and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points.
May I just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulty understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So
that's very peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm
tomorrow
listening. You
morning,
may continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout from tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case laws, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law and our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no? And what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider. And perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheefer was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheefer, as Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning, and underline, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow.
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Mr. Lolo. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's the judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Kumalo have already made, that this is something that's been brewing for some time by Ms. van den Heever. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the Commission and submitted to Mr. Matlala's legal team this weekend. But that's not part of the application that's before the Commission today. It's entirely separate. And that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the Commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed. And we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you, Ms. Hassim.
I'm sorry, Chair. There's one last point that I've forgotten, and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday. And this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlala's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing